Good afternoon, and welcome to this edition of Disability Chat. In this session, Allison will talk about disability planning and juvenile Huntington's disease. You can send a question at any time during the presentation. Just click on the chat function in the toolbar, type your question, and hit send. Your questions will be seen by everyone. This presentation will be available in about a week on HDSA's YouTube channel or by going to hdsa.org/disabilitychat. This will be our last webinar in 2022. We hope you'll join us in early 2023 when we launch our next season of Disability Chats. And now a little about our speaker. Allison Bartlett is HDSA Senior Manager of Disability Programs and is a disability attorney who assists clients with rare chronic conditions like HD to navigate the complex disability system. Allison holds a JHD from the University of Cincinnati College of Law. And now I'll turn our chat over to Allison.
Thank you, Deb, and thank you everyone for joining me today to discuss this complex topic. So what I'll be discussing today is the different definitions between a child and young adult, which is very helpful for understanding everything we're going to talk about today, and then different legal, educational, and financial options for when you have someone with JHD and how to navigate this complex system. First, when I use the term child, I'm talking about someone between the ages of 0 and 17. This is someone who's in education, generally K through 12. The default legal decision-making is the parent. And I talked about this last time, but just as a refresher, the disability options that are available to a child are just SSI. Young adults, I'm talking about someone aged 18 to 30. Education can include high school, college, or trade school. Legal decision-making is self, that is the legal presumption. And then disability for this age group includes SSDI, SSI, and adult child disability. Again, this is what I spoke about in my last disability chat webinar, but it's a good refresher. So we're gonna get started today on legal planning. Legal planning is really important because, again, as a parent of someone with JHD, if your child's under the age of 18, you have all of the rights guaranteed you as a parent because your child is still a child and doesn't have legal decision-making power in the United States. But you lose all parental rights when your child turns 18. And the reason for this is 18 is considered a legal adult in all 50 states. A legal adult is presumed to be able to make their own decisions, regardless of their disability status as a child. There is no state in this country that if your child has a cognitive disability when they're a child, that presumes that disability continues into adulthood. For whatever reason, as soon as someone turns 18, the slate starts at 0. Anything like their past disabling condition history is essentially erased. And so the severity of a disabling childhood condition does not matter once they reach adulthood. There are no exceptions for cognitive disabilities. So what does this mean? This means that even if your adult child has severe cognitive impairments, they will be responsible for all of their legal, financial, and healthcare decisions, and you will not be able to provide any assistance without proper documentation. In our country, in our legal system, proper documentation is guardianship or conservatorship, or depending on the circumstance, it can be a durable power of attorney. And this is a big deal because guardianship and conservatorship is a legal proceeding, which means you are going to have to go to court. There are complexities in this process. So how do you know you're going to need guardianship or conservatorship for your child? What are they looking for? Well, guardianship or conservatorship will be necessary if your adult child will have a severe cognitive impairment and will lack capacity to make decisions and care for themselves. So the adult child will not have so if you decide to go the guardianship and conservatorship route because there's enough impairment that that's not going to be an issue, well, what does this look like for your child? Your adult child will not have the authority to make decisions about his or her personal life or property, depending on what kind of guardianship or conservatorship you have. This means they're going to lose the right to marry, drive, vote, and sign contracts. They will not have the right to decide where to live or make medical decisions, depending on what is specified in your guardianship or conservatorship papers. They can have rights can potentially be restored through court proceedings. The other thing is, all of these rights aren't necessarily taken away based on what kind of guardianship or conservatorship you get. But if you're getting like a standard guardianship or conservatorship that gives you complete legal, financial, and control over the person, it means your adult child is going to lose the right to marry, to drive, to vote, to sign contracts, and things like that. So it's good to be aware of this when starting this process, because what rights do you want your child to have? How progressed is your child? What is going to be absolutely necessary? And traditionally, a guardian or conservator will be appointed if the adult child lacks capacity to meet the essential requirements for their health, care, and safety without the assistance or protection of a guardian, or manage property or financial affairs, or provide for their support without the assistance or protection of a conservator. So the courts are looking at two different ways a person can care for themselves. They're looking at like decision-making capacity. They're also looking at their actual ability to provide food, clothing, and shelter, which is under the guise of health care and safety. Or can they make financial affairs? Is this somebody who's going to be taken advantage of? The courts look at a lot of different things when taking these proceedings into consideration, because you lose a lot of your rights. So it is important to go through this whole process. So when should this process begin if you are confident that this is going to be the right path for you and your child? Parents who plan to seek guardianship or conservatorship should begin gathering information around the child's 17th birthday. And the reason for this is it takes a while to put this in place. This is not a quick or easy process, because you have to file documentation, you have to go to court, you have to gather evidence. So first, this is a legal proceeding and you will have to file documents in the appropriate state court. I don't go into specifics because every state has a little bit different process. I'm giving you a high-level overview of what to expect in any state court, but you will need to look for your specific state rules and regulations to know exactly what to do. Relevant evidence that the court is going to look for is medical record of mental incapacity and activities of daily living, because that goes to their ability to feed themselves, take care of themselves, like do chores, make sure they have a sustainable living environment. Required court documents for this process: report of guardian for an incapacitated person, inventory of estate for incapacitated person. So what does your child have? What financial things do they have? And then account for incapacitated adults. So this is tracking how they live their daily life, where a conservator or guardian would come in, and what kind of things the conservator or guardian needs to do on a regular basis. And then a court proceeding can take 6 or more months, so be ready to petition the courts by the time your child is 17 and a half. There may be some states where you cannot petition the court until your child turns 18, but you want to have everything ready in advance to help expedite this process as much as possible. So what do you need to include in your court petition? You have to include your relationship to the person under the guardianship or conservatorship. So you would need to include your relationship to the child. You would need a description of the disability and how it impacts the person's ability to make decisions. You need reasons why the court should appoint you to be a guardian or conservator. And you need an affidavit or certification from the doctor attesting to the level of functioning. And if your child has JHD, you've likely been working with their neurologist and care providers for years, and I'm sure that your clinical care team would be all too happy to provide this assistance and whatever documentation is going to be necessary to make this process go as smoothly as possible. Once you've petitioned the court, then you will have to have a hearing. You're going to have a hearing before a judge. You would be the petitioner in this instance. If you are the parent of a JHD child, you're going to be the petitioner. And you have to present evidence of the need for guardianship and conservatorship. This is why you want to start gathering evidence well in advance of when you actually start this process, because the more evidence you have, the better. You're going to need to show that your adult child lacks sufficient capacity or understanding to make decisions, that this lack of capacity is caused by a disability, in this specific case, that it's caused by juvenile Huntington's disease, that no less restrictive alternative is available, and that the proposed guardian or conservator is fit and capable. So if you are proposing that you should be the guardian or conservator, that you are capable of handling this responsibility. And generally speaking, 2 attorneys are involved, one representing you, the parent, and one representing the interests of the adult child. This isn't always true. Technically, you can navigate the system without an attorney, but in a lot of circumstances, it can be helpful and beneficial to hire an attorney to help you navigate this process because court systems are not easy to navigate. Certain states have programs in place to help it make it easier to walk you through this process or to find an attorney to help you through this process. Hiring an attorney generally means it's going to cost more money, and not everyone can afford those costs. Some states also have like a grant program if you have financial need and need assistance paying for an attorney and navigating this process. I'm sorry I didn't include specific states. It's a lot to go through every single one of the 50 states, but just know that you may have a grant program in your state. So definitely do some research to see if you have a grant program for guardianship or conservatorship. And when the courts make this decision, the order of preference for a guardian or conservator is parent first, then adult sibling or other adult family member, close friend, and last is court-appointed professional guardian. So the courts very much want to see that family and loved ones are the main providers and caregivers. And then what are the responsibilities of a guardian or conservator? You're going to be subject to court supervision to prevent mishandling of finances or taking advantage of the adult child with JHD. Sometimes a guardian or conservator can be reimbursed for their expenses and paid for their services. Again, this is state specific, so you will need to check with your state. And when a guardian or conservator can no longer serve, apologies for my clerical error, a new person will be appointed. So you can have that discussion and put that in place when you get guardianship and conservatorship set up. If you as the adult parent are not sure that you will outlive your child, who do you want to put in place? Is it going to be like you, the mom, then the dad, then an adult sibling? You have the power to set that up when all of this gets decided to make sure the person, like the JHD adult child, will continue to be cared for by a member of the family. Like you can put the order of how you want things to go if you can no longer serve as the guardian or conservator. And then you will need to file a regular report with the courts about the status of your adult child and how their money is being used and how they're being cared for. Generally, you do this about once a year. Okay. So now that we've talked all about the guardianship/conservatorship process, the reason I use those words interchangeably is because some states use one word, some states use another. Be aware of that. There are alternatives depending on the extent of capacity in your child. So some children with JHD have a lot more mental symptoms and limitations and may require guardianship or conservatorship because of mental incapacity. Other JHD children show more physical limitations and they may not need guardianship or conservatorship right when they turn 18. So what are some options? Another option is durable power of attorney. This is if an adult child has cognitive capacity on their 18th birthday. This is a best case option because it protects the adult child's decision-making power. It gives them say in this process. It provides decision-making authority when there are episodes of incapacity, and it can ultimately make guardianship or conservatorship unnecessary. If you have a durable power of attorney, and you have a clause in there that states when your chosen physician signs an affidavit and submits it to the state that your child has become mentally incapacitated, you don't need to get guardianship or conservatorship because a durable power of attorney will continue to do all of those things. Guardianship and conservatorship really are what you have to rely on, is if by the time your child has turned 18, they no longer have mental capacity, you won't have any other option. But if your child does still have mental capacity, a durable power of attorney is great because it will negate the need for ever having to go through court to get the guardianship or conservatorship. Another thing you can have in place is family guidance. This is when an adult child retains decision-making capacity, but a family member is available to provide advice and help. The downside of this is if an adult child is too easily influenced, then guardianship or conservatorship might be the better option to just make sure they're protected and they don't get taken advantage of. Another option is assisted or supported living services. This is a good option if the adult child only needs assistance in a few areas. And then the last thing having a financial representative. This is somebody who acts as a representative payee if your child has Social Security disability or joint ownership of bank accounts to help the adult child manage their finances, make sure money is going in and out correctly, and bills are being paid. So again, depending on where your child is in the process, where they are with mental capacity, these are some different options that might be really good instead of guardianship or until you need guardianship or conservatorship. And it's impossible to predict how that will play out because everybody is different. Every JHD child is different. Every HD adult is different. And so their symptoms and limitations are going to be unique to them. So there's not a set timeline for when these things may be necessary because everybody looks different. Just be aware you have options to fit your needs. There is nothing that is one size fits all. Whatever is specific to your family, there are options for that. So now that we've talked about the different legal standards and what to expect as far as it comes to like decision-making power when your child turns 18, we're going to go back and we're going to talk about education. And education is really important because education is mandatory for grades K through 12, including children with special needs and disabling conditions. Even if your child has JHD, they are still going to be required to go to school because of the way the laws are written in this country. And unfortunately, there are many barriers for children with disabilities, including physical inaccessibility, the entire accommodation process, lack of individualization, ineffective dispute resolution if parents aren't happy with how something's going on in the school, and then just general negative attitudes. And this makes it really difficult for a JHD family because you already are living with a lot of complexities. You don't need to be involved in a fight with the school just to make sure your child is getting what they need. But we all know what happens. So what are some of the things that you can use to help navigate the education system and make sure your child is getting what they need and deserve? So there are programs to help children with special needs and disabling conditions in K through 12, and then there are different programs to help young adults in higher education. So specifically for K through 12, there's a 504 plan, and then there's also the Individualized Education Program. What's really important to notice about these two things, a 504 plan is making the environment work. So especially if your child has a physical disability, how can they exist in their school environment? An IEP is how to make the education work. So there are certain children who need both. Some children need a 504 plan, some need an IEP, but a lot of the struggles when we're talking about things in education, it has more to do with an IEP than a 504, because again, it's making the education work versus making the environment work. And a 504 plan in a lot of circumstances might just be putting the school on notice that there may need to be additional programs in place in the future. Like if your child has diabetes, they would need a 504 plan. There are certain things that like just put the school on notice, but it doesn't mean the school has to actively do something. An IEP means the school is actively working with you to provide benefits. And then for young adults in higher education, a lot of the times when we're talking about these programs, it's really the Americans with Disabilities Act accommodations and then student loan forgiveness. A child has any disability and the disability interferes with a child's ability to learn in a general education classroom. For a 504 plan, the definition of disability is very, very broad. So when you're creating a 504 plan, it has to be created by a team of people who are familiar with the child and understand the evaluation data and service options. So this includes the child's parent or caregiver, general and special education teachers, and the school principal. Unlike an IEP, There is no standard plan. This does not have to be written. There's a lot more flexibility with a 504 plan. Generally, they include things like specific accommodations or support services, names of who will provide the service, and name of the person ensuring the plan is implemented. The school must notify families about an evaluation or change in placement, but it doesn't have to be in writing. And you'll see a big difference between 504 plans and IEP plans when I get to that next. Because everything with an IEP has to be in writing, but a 504 plan does not. It helps to get things in writing. So if there's ever an issue, you need to clarify something or you need to go back to the school to get something changed, having it in writing will make it a lot easier, but the law does not specify that it has to be in writing. The school, a parent or caregiver's consent is required for the school to evaluate a child. These plans should be reviewed every year, and a child reevaluation is done every 3 years. Again, that's like best practice. It's not as strict as an IEP. And again, this is at no charge to the family. So now we're going to talk about individualized education programs, or IEPs. So these are also for mental or physical disabilities. They provide individualized education and related services to meet a child's unique needs. Again, making the education work. And then these are also provided at no cost to families. So eligibility for an IEP, your child has to have one or more of the disabilities listed below. And as you can see, this is a much more specific list of criteria. Granted, learning disability or other health impairment is very, very vague and broad. And then you also have to show that the disability interferes with a child's educational performance and ability to learn, and that your child needs specialized instruction to make progress in school. An IEP team is very specific. It has to include a child's parent or caregiver, at least one general education teacher, at least one special education teacher, a school psychologist, or other specialist who can interpret the evaluation, and a district representative with an authority over special education services. Everyone on this team must be present for an IEP meeting. So that's what's specified under the law for who has to be there for an IEP. What's not specified is that the team can include a JHD specialist and an IEP or special education advocate. And really, the team should include that, especially because of the rare and unique nature of what JHD is. And a lot of times, while they shouldn't be, these kind of meetings can get adversarial because the needs of the parent and the child don't always match what the school system can provide. So having an advocate there who understands the language, who understands your rights, who understands your needs can be really beneficial to make sure what your child needs is being presented in this meeting. And you have every single right to have an advocate. So what is the point of an IEP? An IEP sets learning goals and describes the services that the school will provide. An IEP has to provide the child's current level of academic and functional performance, annual education goals, services the child will get, the timing of services, any accommodations to the learning environment, any modifications to curriculum, how the child will participate in standardized tests, and how the child will be included in general education classes and school activities. For notice, the school has to notify families about an evaluation, a change in placement or services, or an IEP meeting in writing. While any of this is happening, families do have a right for a stay put. That means to keep current services in place while there is a disagreement over the IEP. And that's really important to know because there may very well be a disagreement over the IEP. But while things are changing, your child should continue to get those services and benefits. For consent, The parent or caregiver's consent has to be in writing. You have to have everything in writing in order for the school to move forward with an evaluation or to do anything with an IEP. The plan has to be reviewed at least once a year, and a child will be reevaluated at least every 3 years. Again, costs for public schools are free, but it is important to know that if your child is in a private school that does not receive government funding, they are not required to provide free, appropriate education or IEPs. And so a lot of this stuff is, all of these laws are specific to public institutions. The exception is if the private school is getting public funding. So I've talked about just like a high-level overview of what a 504 is and what an IEP is, but how does this really play out if you have juvenile Huntington disease, if you have a child with JHD? What do you need to know? What does this really look like? Well, first, you really need to have a legal advocate during this process. You can either have a special education advocate or a special education attorney. A place where you can find more, so for a special education advocate, a place to find more resources and information is A Day in Our Shoes. A Day in Our Shoes is written by a special education advocate. Say that word 5 times fast, it's hard. But she has spent her life being a special education advocate, and she has a lot of really interesting resources and tools on her website to help like prepare for this process. You can find advocates or attorneys through the Council of Parent Attorneys and Advocates. You can use your state disability rights organization or the ARC. You can also go to your state Department of Education. I know specifically in Virginia, I just happened to find this on Google, their state Department of Education has an entire list of advocacy organizations that deal with IEPs and special education. If you want to find a special education attorney, you can try the state bar, the state Department of Education, or disability law centers. So what's the biggest difference between an advocate and an attorney? Well, an advocate is a guide through the special education process, whereas an attorney is a legal representative in a dispute with the school. Anyone can be an advocate, but to be an attorney, you must have required licensure. An advocate cannot practice law. An attorney practices law, can draw up legal documents, and can represent you in court. Schools tend to be more open to advocates, and they're more wary of attorneys. An advocate is likely going to charge a fee. An attorney is likely going to charge a more expensive fee. So how do you go through the process of hiring an advocate? You want to make a list of potential candidates in your area, and you want to interview multiple candidates. You want to get to talk to different people and know if they're going to be the right fit for you. What is their experience? What services are covered? What is their fee? It's important to know that there are very few low or no cost advocates. There are some that exist, but there are very strict financial criteria. It's one of those things like trying to apply for SSI. If you don't meet the strict financial criteria, you're not going to be eligible. And in order to get an advocate, you're going to have to pay out of pocket. I didn't look up the average cost of an advocate, but I was reading that they can cost anywhere from they can cost up to $200 to $300 an hour, probably depending on their specialization and what kind of assistance you need. But again, when you have a JHD child, JHD is a rare condition. There are going to be a lot of complexities with a JHD case that do not exist for other cases. Having an advocate is going to be really helpful to make sure your child gets what they need and deserve. So what are some other things to consider and understand about this process? Well, you're going to want to understand Department of Education lingo. You don't talk in Department of Education lingo. That is not something you're going to be familiar with. So they talk about things like class size ratios. Well, in middle school, a special education classroom should have no more than 12 students to one teacher, and in high school, it's 15 students to one teacher. That's still a lot of students with special needs to one teacher. They're also going to talk about things like accommodations. So there's specific testing accommodations, and then there's classroom accommodations. Examples of testing accommodations include extended time, having questions or directions read and reread aloud, answers being recorded in any manner. So instead of the child having to fill out the multiple choice on the test, they can just physically say the answer and someone else can fill in the bubble. Getting breaks as needed, extra breaks or extended breaks. So what does an accommodation look like in the classroom? It's having a multisensory approach when presenting information. So visual, auditory, and tactile. Repetition of skills and concepts previously introduced. Checklists for long, detailed tasks or long-term assignments. previewing information before the lessons, reducing auditory and visual distractions, shortened or modified assignments, frequently focus or redirection, and movement breaks. And that's just a small chunk of examples. There are a lot more other examples that your child could benefit from for classroom accommodations and testing accommodations. It's also just important to know that this system is really complex, just like any disability system. You're going to want to get an overview of what to expect, how things should go, and what will be discussed. And that's another benefit of having an IEP or special education advocate. Know that the Department of Education has a very specific job to do. So what does this mean? It means that their system is set up to streamline the process. It puts kids in boxes, but it is not always the right fit. And you have to be aware of that people outside of your community, outside of the JHD community, are making the decisions about the needs of the community. The Department of Education and IEP planning was going to have trouble understanding JHD because JHD is degenerative, but goals of an IEP are for progress. Progress for a JHD child may look very different for someone with ADHD or autism or any other kind of disabling condition. JHD goals will likely be more connected to related services and accommodations than to the academic setting. These are going to include things like occupational therapy, speech and language therapy, again, more service related than academic goal setting, and things like an exemption from state testing. And this is why it may benefit you to have a JHD specialist in your meeting who can push for, because the point of an IEP is to make progress. But what is progress actually going to look like in a JHD student? And again, that's going to depend if your JHD child has more cognitive limitations or more physical limitations. You may have two children who have completely different sets of limitations, so their IEPs will look completely differently, which again may confuse the school even more because they likely haven't worked with a JHD child, or it's been a long time or whatever. But know that an IEP is not truly designed for someone with a degenerative condition. The goal is to try to make somebody a functioning member of society. Well, what does that actually mean for your child versus a child with autism? Is your JHD child going to be able to work? Is your JHD child going to be able to live independently? Your goals are trying to make their quality of life the best that you can. So again, it's going to be occupational therapy, speech and language therapy. And I know everything I'm discussing right now is incredibly difficult. And these conversations are difficult. And that's why it can be beneficial to have an advocate in there with you, because this is going to be an emotional process. This is going to be a difficult process, because not only are you advocating for your child, you're going to be educating the entire system on what JHD looks like, what it is, and how it's going to impact them. And that's hard. That's a lot to do on a day-to-day basis. It's also important to know what the limitations are of all of these things. Schools are short-staffed. Most high schools do not have a counselor or a therapist. IEP hours will not always be met. Schools should definitely communicate if they're short-staffed or if a plan item couldn't happen that day, but that doesn't even always happen. And you need to be able to trust the teachers and staff. Do you have safety concerns? Do you trust the teachers with your child? Because that matters. And a lot of times these schools are in outdated buildings. A lot of schools are still not wheelchair accessible, or they're not able to easily accommodate physical disabilities. So these are things to take into consideration when you're trying to access resources and benefits for your child. You're legally entitled to all of these things, but we know being legally entitled and how things play out in the real world look like two different things. And there's not always an easy answer to that, but that's why it's always good to have the connection, the relationship with an advocate, or to understand that you can have access to a special education attorney in case that you need one. And this is always important. You always have access to your child's school records. You can always request them. You should always have a copy of these things on hand, so you know what's supposed to be happening and how things are being managed in your child's life at school, since they have to spend at least 170 or 180 days in school while they're in K through 12. Okay. So all of that stuff I was talking about was specific to child education. Now I'm going to talk about young adult education. This specifically is high school or college and higher education. So for high school, you could easily have a child who turns 18 and is still in high school. Well, what does this mean? They do actually have something called an education power of attorney. This allows parents to continue making education decisions. Your child will need to have capacity to sign the document, but if they have capacity to sign the document, you continue to act and make all of those decisions. The link that I've included, this is an education power of attorney document sample. This is specific to the state of Virginia, but I think it's a good document to look at and just have an understanding, and you can probably find it in your state, but this is a good option to have. Another thing that could happen is a school could appoint an educational representative if the adult child does not have capacity to make decisions and parents do not yet have guardianship. The school kind of has to start that process. Not every school may do it, but you can always ask. Okay, so a young adult in high school, that's something manageable. A young adult in college is a completely different ballgame. And the reason for this is with decision making, parents do not have any access or right to make educational decisions in the college setting. Again, an exception is for an education power of attorney. But if you have a disabled child in K through 12, the school has an active responsibility to be aware that your child has a disability, to put testing in place to get accommodations. That does not exist at all in college. An adult child will have to disclose the need for accommodations to the school and request the accommodation process. Under the Americans with Disability Act, colleges and universities are not required to identify students with disabilities. They have to self-identify and notify the school. The schools are required to inform applicants of available aid, services, and academic adjustments, but they are not required to do anything unless the student says something, or the parent can say something if there's something like an educational power of attorney or some kind of power of attorney document in place. But otherwise, it's going to be completely up to your adult child to speak for themselves. And that can be really difficult. That's a lot to put on an adult child who may have some cognitive impairments. So it's really good to make sure that you have protections in place or to have these discussions with your young adult child. The other thing is, the young naivete of youth when, you're like, oh my gosh, I'm 18, I'm going to school. You may not want your parents' assistance. You may not want to be labeled with a disability. You may not want accommodations, even though you really need them and can benefit from them. So that definitely adds an added level of complexity to this process. And we know that this can happen. You may have a JHD child who has a little bit later onset. And so they're not super cognitively impaired when they start college, but they may have some cognitive impairment. But you can't, if they have capacity to make their own decisions, you cannot force them to put any accommodations in place if they do not want them. That is how this process is set up. So just know that as a parent, it may be really hard to stand by and watch them struggle when they don't need to. And you can have those conversations, but you cannot force them to put accommodations in place if they don't want accommodations in place. And that's hard. It's hard to see a loved one struggle, but that's the way our legal system is set up. Like I said, you could always have the option of an educational power of attorney. You could see if you have a durable power of attorney in place. But if your child specifically does not want accommodations or has not disclosed information to the school, you cannot force them to disclose this information to the school if they don't want to and they have capacity. One thing that is really important to know, because I am a huge proponent of letting anybody with HD or JHD live their dreams and do what they want. You can get student loan forgiveness for a total and permanent disability discharge. If your child wants to go to school, let them go to school. It is really important to know that this is only for government loans, not private loans. Do not let your child take out a Fannie Mae or Freddie Mac private loan. The student loan forgiveness is specifically for federal direct loans, federal family education loans, and federal Perkins loans. How you are eligible for discharge of your debt as so there's 3 different ways it can be done: through the U.S. Department of Veterans Affairs, Social Security, or a physician's certification. Through the VA, if you get a service-connected disability that is 100% disabling, your loans will be discharged. or if you have a totally, oh my God, if you have a total disability based on an individual unemployability rating, your loans will be discharged. If you are found disabled through Social Security disability insurance or supplemental security income, your loans can get discharged. I believe you have to have a condition that is not likely to improve. I will verify that. But generally speaking, if you've been found disabled, like more permanently disabled, either unlike slight chance of approval or not likely to improve, your loans can get discharged. And then the other way is through a physician certification that your condition is either expected to result in death, has lasted for 60 months, or can be expected to last for a continuous period of at least 60 months. You do have to actively complete a discharge application. So just being approved for Social Security disability is not going to discharge your loans, or being found that you have a service-connected disability is not going to just discharge your loans. You will have to complete an application. Okay. So now that we've talked about legal planning and understanding education resources, we're going to talk about financial planning. So financial planning, I always like to talk about Medicaid because Medicaid is much easier to obtain for a child. It does vary widely from state to state and age range. The example I have below is for the state of Delaware. A child that is 0 to 1 in age has the highest financial limit. It is 212% of federal poverty level. But as soon as the child turns 1, that reduces to 142%. And then once the child turns 6, it reduces further to 133%. And a lot of states look like this. It is easiest for an infant to get Medicaid. And then there's usually a reduction between infant to a child who's 1 to 5. There's not always a further reduction once the child turns from 6 to 18. Some states do that, some states don't. But just be aware that Medicaid amounts generally change from infant to toddler to child. A parent's income is deemed onto the child. The exception is the CHIP, the Children's Health Insurance Program. This exists if an eligible parent makes too much money for Medicaid, but is not otherwise covered by any other insurance. They want to make sure that children are getting their care. They're getting medical care. It is important, so what I have up is the status of state Medicaid expansion decisions. This is important to know because if you live in a blue state, it's going to be a lot easier for your adult child to get Medicaid. If you live in an orange state, your adult child is going to have to be found disabled from Social Security in order to get Medicaid benefits. So if we go back, child Medicaid is completely based on the parent's income, with the exception if the parents don't have health insurance but make too much money otherwise. When your child is a young adult, even if they're living at home, parents' income no longer counts. There is a discrepancy. So for SSI, parents' income stops counting at 18, but for Medicaid, a parent's income doesn't stop counting until they turn 21. For Medicaid expansion state, if your child is making less than 133% of federal poverty level and meet their asset limit, so they have less than $2,000 in resources, it can go up to 5, but generally if they have less than $5,000 in resources, they should be eligible for Medicaid. If you do not live in a state that has expanded Medicaid, like I said, your child has to be on SSI or SSDI. And the reason I talk about Medicaid as part of financial planning is because there's financial criteria, but also because Medicaid covers health insurance, which is an important part of financial planning. Now we're going to talk about more traditional financial planning. A really important thing to be aware of for somebody with juvenile Huntington's disease is an ABLE account. ABLE accounts are tax-advantaged savings accounts for individuals with disabilities and their families. The beneficiary of the account is the account owner, and income earned by the accounts will not be taxed. The reason I specifically mention these for JHD is because it limits eligibility to individuals with disabilities that started before 26. If you are under 26 and are receiving benefits under SSI or SSDI, you are automatically eligible to establish an ABLE account. The reason you want an ABLE account is because the funds in an ABLE account are not counted as a government asset or benefit, so it will not impact your child's ability to get something like SSI. It is important to know that you can be over the age of 26 to start an ABLE account, but you had to have had onset of your condition before your 26th birthday. There are limits to how much money that can be put into an ABLE account. The total annual contributions is $15,000. State limits range from $235,000 to $529,000, but that's still a good amount of money in the account. And there is a further limitation. If the disabled individual is receiving SSI, they have to have less than $100,000 in the account. But again, that's still a helpful amount of money to be able to be used to care for the child. And that's on a rolling basis. It just has to stay under that amount every year. So let's say you start the year off with $100,000, you have to spend down $25,000 for whatever, but you're gifted $15,000. Like, then at the end of the year, you'll have $90,000 in the account. So it's on a rolling basis. So you're allowed to spend money in the account and put money back into the account. And so what kind of expenses are allowed by ABLE accounts? Anything that's a qualified disability expense, which means any expense related to the designated beneficiary, so in this case, your JHD child, as a result of living a life with disabilities. This includes education, food, housing, transportation, employment training and support, assistive technology, personal support services, healthcare expenses, financial management, and administrative services. Any expense that helps improve health, independence, and quality of life counts as an ABLE account expense. So this is a really broad definition, which is another benefit of the account. And part of the appeal of an ABLE account is they're much more affordable to set up than, say, like creating a special needs trust. And you can go to the ABLE National Resource Center to learn more about ABLE accounts. The reason you want to start at the National Resource Center is because every state runs their accounts a little differently. They are not all the same. You do not necessarily have to use your state program, and you can compare different options because there's different eligibility criteria, there's different amounts that you need to put into it to start the process. A lot of times ABLE accounts are managed accounts, and they will have different interest rates. Wow, I had to get took way too hard to get to interest rates. But yeah, this is a really good resource because you can see all of the different state programs and you can pick an ABLE account that works best for you. And like I said, this is a really great option, especially for JHD families and individuals, because it's going to be a lot more cost effective to set up. It's going to protect benefits. It can be used for a wide range of reasons. And it's not going to interfere with your ability to access other government benefits like SSI and Medicaid. And then the last thing we're going to talk about today is special needs trusts. This trust is meant for a dependent, so your JHD child, who receives government benefits such as supplemental security income or Medicaid. Setting up the trust enables the disabled person to receive income without impacting or forfeiting their government benefits. There are strict rules regarding how the money can be spent. And this is a good option if a parent wants to leave money to a child with HD. There are three different kinds of special needs trusts. There's first-party trusts. This is funded by the resources or income of the disabled individual, but it has to be established by a parent, grandparent, legal guardian, or by the court. So this could not be set up by the JHD child. It has to be set up by somebody else in their life. Then there's the third-party trust. This is created and funded by someone other than the disabled individual for the benefit of the disabled individual. It cannot hold funds that belong to the disabled individual. If you have a JHD child, you're likely going to set up a first-party trust because if they're a child, when you're setting this up, they're likely not going to have any of their own benefits or resources or income. So you're not going to have to worry about, you're likely going to set up a third-party trust because your child is likely not going to have any of their own income and resources when this is set up. A first-party trust is likely more for somebody who's a little bit older when they develop their disability and may have worked and have some of their own resources. That person may have to have two different kinds of special needs trust. The last kind of special needs trust is a pooled trust. This can be created by the disabled individual directly. So again, this might be beneficial for somebody whose onset is a little later in life. It's managed by a nonprofit organization. How these work is a pooled trust. Individuals have separate accounts, but all of their money is pooled together and managed by the nonprofit. This is a more affordable option if cost is an issue. It also gives families access to professional trustees and account management, and it can offer a sense of stability because they don't have to worry about replacing family members. But these are just good options to look into if you want to pursue a special needs trust. And this was just an overview of what different things look like. And here are some resources to find out additional information about a lot of the things I've talked about today. So the Special Needs Alliance, they specialize in things like special needs trusts. The ABLE National Resource Center. If you want to understand more about special education, how to get a 504 and IEP, www.understood.org is a really great place to start. There's a lot of resources and information there. And then if you want to understand more about guardianship by state, like the actual legal standard and what court you would file in, going to the American Bar website, or this document is a good place to start. Are there any questions?
Thank you, Allison. I do want to remind folks that you can ask a question through the chat feature. So if you have any questions, please do put them into the chat so that Allison can answer them.
We did get a question about durable power of attorneys. So yes, I talk about this in other webinars that I've given, but there's more than one kind of power of attorney. There's a durable power of attorney and a general power of attorney. In the HD community, you want to have a durable power of attorney because that will continue to exist even after your loved one has become mentally incapacitated. A regular power of attorney expires once someone is found to be incapacitated. So if you have a durable power of attorney, you shouldn't need to get guardianship because it will continue to exist even once the person no longer has capacity. We got a question, can you have a special needs trust and an ABLE account? That's a good question. I didn't actually look into the complexities of that, but I think you can. Really, the difference, what makes an ABLE account unique is you have to set it up before you turn 26 years old. And it's much more affordable to set up. Like you might just have to spend like $20, $25, or $50 to set it up. If you're going to set up a special needs trust, that's likely going to cost a few $1,000s to work with an attorney to set up the specialty trust, but I'm pretty sure you can have both of them.
I want to remind folks that this webinar has been recorded, and all of the information that Allison provided today, as she has over the course of the last 12 months in her series, is available on HDSA's website and on the YouTube channel. So again, it would be hdsa.org/disability-chat or HDSA's YouTube channel. We do have one that just came in, Allison. I think you can see it.
Okay. So first, I have two questions. First, what is the benefit of a trust? You want to have a special needs trust if you want to protect somebody's assets and make sure they have finances to continue for their care and well-being, but also want to make sure they continue to access something like Medicaid or supplemental security income. Medicaid and SSI have really strict financial criteria. You have to have less than $2,000 in resources as an individual or $3,000 in resources as a married couple. So if you have assets in a special needs trust, the government doesn't count that as an asset. So you can have $100,000 in your trust and continue to get SSI and Medicaid and use all of that money for your care. And that's okay. If you don't have money in a special needs trust or an ABLE account, all of that will count as assets and resources against you, and you'll likely lose your government benefit. Okay, then there's a question about, I believe someone with JHD has SSI and is getting benefits under their parent's account. So if you're getting benefits under your parent's Social Security account, that means they should become Medicare eligible after 2 years of receiving qualifying payments. The other thing is they may be eligible for a Medicare, I'm sorry, I'm having a brain fart. I'm having a lot of those today. I'm sorry, guys. This is a complex topic and my brain is just like, no. Medicare savings programs. That's where I was trying to get. So you're going to want to contact your state health insurance program. They're called state SHIPs. And a lot of times these are geared towards Medicare benefit counseling, but it includes the crossover of like Medicare and Medicaid and what you can get all together. So if somebody's getting SSI and their parents SSDI, they're definitely going to be eligible for a Medicare savings plan, and you should see when their Medicare eligibility is going to start. But if you're getting adult child disability benefits, and I mentioned this in my last webinar, because your parent is deceased, disabled, or retired, and you didn't have work enough under your own credits, it means you're also going to get their Medicare. And so your Medicare is going to start early. I don't know how long this individual has been receiving SSA payments, so I can't tell you when their Medicare will start. But if you're receiving adult child disability benefits, you are going to be eligible for Medicare within a 2-year time frame. And I just wanted to say thank you all for joining me today. I know this is definitely a complex and emotional topic, but I just want to make sure we get these resources out to the community and start having these conversations because they're very necessary.
Thank you, Allison. Unfortunately, we've had some sirens outside my window, which is why I've been silent for a while because it's just blaring. We do want to remind folks that this is our last webinar for 2022. We will be posting the schedule on an email alert once we get 2023 ready, and we welcome you to join us for a new series of disability chats when we launch again in 2023. Until then, hope you and your family have a happy holiday season. And thank you very much for attending. And thank you, Allison, today for your webinar.